talking about right now refers only to the United States. If you want to get a patent outside the United States, you have to apply for one in a specific country, using much of the same rules and procedures that I'm describing for the U.S. Or you can apply for an international patent application as well. So, patents and intellectual property is very geographic. So you get to pick and choose which countries you want to be in, and usually it turns into the biggest markets, where you think the markets are going to be for your particular product.
But if this is enforced, in other words, if I have a patent in Germany, this is enforced in the United States?
No, it's only enforced in Germany. That's why I say patents are very territorial. A United States patent can only be enforced in the United States. A German patent can only be enforced in Germany. A Chinese patent can only be enforced in China. So that's why, if you're a big company and you're doing business worldwide, you have to think about where are your big markets, because you can't, as a practical matter, you can't get a patent in every country in the world. It's prohibitively expensive. So you have to pick and choose which are your main countries, where you're doing business, where do you think infringement may happen, and once you've answered those questions, then you can go on and get patents in those particular countries to protect yourself. Okay, subject matter. What can you get a patent on? Well, patents can be obtained for most things, but not everything. There are some exceptions on certain subject matter that you can't get a patent on. But what you can get a patent on are basically spelled out in patent laws. Machines, compositions of matter, articles of manufacture, and processes, improvements on any of these. And then there are two separate kinds of patents called design patents and plant patents, which I'll talk about in a moment. So some examples of machines are basically things with moving parts. Just some examples would be a sewing machine, complex machine really, pliers, a more simple machine, just two pieces of metal, telephone, computer, or a protein sequencer. So they run the gamut of simple to complex.
So if iPad, for example, which is made I found a better, I can improve that with just minor modifications. Who owns that new invention?
Well, you would own it. It would depend on how you wrote the application and how you drafted the claims. But if you made a new machine, with an improvement over it that's distinguishable over the iPad, then yes.
It's no new machine. I'm using basically the iPad.
With improvements?
With improvement.
Yeah, then you would get what we call these so-called improvement patents, where you would basically disclaim everything the claim reads. It's kind of funny the way the claim reads is you disclaim the entire iPad, and all you claim as your new bid is your new improvement. So it's actually a very, very narrow patent.
So I couldn't market the iPad.
And no, you couldn't market the iPad. I think Apple would have a question about that. So machines, we also have compositions of matter, which are basically an area that I work in quite a bit. New compounds or chemicals, pharmaceuticals, nucleic acids, proteins, these kinds of things. Articles of manufacture are basically things without moving parts. Something like a broom or a bottle or a lamp. You can get an article of manufacture patent on that. Processes is also a big area. Methods of doing things, methods of purifying drugs, methods of treatment, methods of treating disease, and even some business methods are all patentable by way of a process patent. So, what things can't be patented? Yeah.
How would you classify something that was developed as an add-on to another piece of technology? Say they have a microscope that can be added onto an iPhone. Is that its own machine?
Well, yeah. Well, the way you can do that, the way I would do it is I would cover the the add-on bit by itself, you know, independent of what you're adding it on to, just the bit by itself. And then you can also claim the combination of the new part plus, you know, some generic description of the phone, you know, because you don't want to be limited to say it's just an iPhone 6 Plus.
Right.
You know, to say any kind of portable telephone, you can attach this new lens.
So those would be two separate patents?
There would be two separate inventions. They may be two separate patents, but they'd certainly be two separate inventions, whether they may be in the same patent or not, depending how close they are. But I think you can get creative on how you think about how you do that. But I would definitely want to cover the new bit that you developed independently from the product. So what can't be patented? There are a handful of items that can't be patented. Laws of nature can't be patented. This was the subject recently of a Supreme Court case where they held that natural principles and laws of nature are not patentable. These are things like, you know, basic equations like F equals MA, PV equals nRT. You can't patent those kinds of things. Naturally occurring compounds, that is to say, as they existed in nature, also can't be patented. This was also the subject of a recent Supreme Court case where isolated DNA molecules that were the same as found in nature, even though they were isolated, are not eligible for patent protection because they're naturally occurring. The court also found, though, that cDNA, people know what cDNA is? Basically, you have a piece of DNA that has some coding portions and non-coding portions interspersed. And what you can do in the lab is basically take out the non-coding portions and link together all the coding portions. That's what cDNA is. That was eligible because that particular compound is not found in nature. So these two have been, and I was just talking with Professor Rabi about this a little bit ago, these two court cases have really turned a lot of the biological and pharmaceutical patent practice on its head because there are some discoveries about, for example, novel antibiotics that happen to be naturally occurring compounds that are being used as therapeutic treatments, and they can't be patented because they're naturally occurring compounds. This whole area of the law is in a big state of flux right now, and it's we just have to see how it all plays out. The Patent Office has promulgated some rules back in December trying to deal with some of this, but a lot of the stakeholders, the big companies, universities as well, who are coming up with new uses for these naturally occurring compounds, they can't get them patented because of this court case. So it remains to be seen how this all resolves. Yeah.
How long have plants been patentable in general?
How long have it been? I don't know how long the particular statute has been on the books. At least as long as I've been practicing, and that's been, you know, since the mid-'80s. Plant patents, which I'll talk about in a sec, are kind of neat because they have these pretty pictures of the plants. A third category are abstract ideas. These are not patentable. These are, for example, computer-implemented methods that use, for example, you know, a known process. The only difference is that you're doing it on a computer. These types of things have been held not to be patentable subject matter as well. And I talked to my colleagues in the office who work on software patents. You know, and they're up in arms about this because I said, you guys are where I was about 2 years ago on this stuff. Is the issues with the biotech patents and the naturally occurring stuff is it's gone through, you know, more debate and things. The prevention of some of the software stuff is relatively recent, so they're just scratching their heads on this. But again, it's an area that it will be resolved soon, I hope. And the fourth area is, of course, you can't get a patent on technology that's already known. Part of the patent bargain is that types of patents that are out there, I alluded to some of this earlier, and I showed you one earlier from Yale. That's what we call a utility patent. A utility patent, that's the vast majority of patents that you see today. They cover the machines, the compositions of matter, and processes and improvements that I talked about earlier, including the biotech patents, which are near and dear to my heart. Another type of patent is a design patent. The design patent basically covers just the ornamental features of an article. A good example of these are tire treads. A lot of the tire manufacturers like Goodyear and Hankook and a number of these tire manufacturers, tires have been around forever. You can't get a new patent on a tire. So what they instead do is they go for the new tread designs, and they get them by way of this kind of design patent. And the patent is really interesting because all it is pictures. It just shows you, here's my tread design, and that's what I'm claiming is my patent. So that's a good way of getting a design, a good example of a design kind of a patent. The plant patents, which you asked about earlier, are a special kind of patent. There's only a couple of firms that I know that work on these. They cover asexually reproducing plants, and that means plants that have been put together by grafting, for example. Sexually reproducing plants are not covered under this. They're covered by another part of the law is called the Plant Variety Protection Act, which I'm not going to talk about. But you can't get on asexually reproducing plants, these nice colorful patents with pictures of the plants and flowers. And then there's a fourth type of patent. It's actually a patent application that we use a lot, especially with the new laws going into effect, where it's a race to the patent office. It's a provisional patent application, which is basically an informal type of an application. It's a quickie disclosure. You put a cover sheet on it and send it off to the patent office. And that does a very important thing. It sets you up with a filing date. And so when I was talking about it's a race to the patent office, when you file that application is key. And so the provisional application lets you do that very, very quickly. So I talked about some of the types of patents. Now, what are the requirements for patentability? In other words, what do you need to put in your application so that you can actually get a patent? Well, there are basically 4 requirements. The first is that the invention has to be useful. That is to say, the invention has to have a utility. And believe it or not, there are some that get rejected on this basis that says that there's no utility. It's usually a pretty low standard, but it has to be useful for something, and it can't be what the courts call a throwaway utility. In other words, you can't use it for, you say, well, it's useful for landfill. No, that's not a good enough utility. It has to be useful for something. The invention also has to be novel. That is to say, it has to be different than what has come before. So in patent language, what we say is it's not in the prior art. The prior art is what we call everything that's come before you. All the publications, some total of knowledge. And then thirdly, the invention can't be obvious. So it can be useful, novel, but it also has to be not obvious in light of the prior art. So here's an example, just a quick example. Let's say I've invented a pen with blue ink. And the prior art is a pen with black ink. Okay? My invention is useful because it's a pen with blue ink. I can write with it. So there is some utility there. It's novel